Good afternoon to you, Fáilte Roth. You're very welcome to our webinar today, Multi-Unit Developments Regulation of Property Management Agents. David Rouse is my name, Multi-Unit Developments Advisor with the Housing Agency. We're very pleased to have you with us for this session today, which we hope you will find of value in your involvement in the multi-unit developments and owners management company sector, whatever that may be. We have nearly 800 people registered to attend today's session, and very grateful to you for your time at lunchtime today joining us. Here's our timetable for the session. I'm going shortly to run a very quick poll of or a survey of the audience, so please identify yourself in terms of your involvement in the sector, and I'll run that right now. This is an anonymous survey, so please let us know who you are in the sector, so we can get a good sense of what your involvement is. So, are you an OMC director, a property management agent? Are you in the AHB or local authority sector? Are you a homeowner occupier, an investor, a landlord? Maybe you're a tenant or a renter. Maybe you're in the legal sector, or maybe you're in construction or accounting or finance, or maybe you're other. So if you could please fill that up, I'll run that for another couple of seconds, and we very much appreciate your letting us know who you are, because it allows us to design our future sessions with you, our stakeholders and audience in mind. As I say, this is an anonymous survey. It's just to get a sense of the audience. And so feel free, the maximum number of responses would be greatly appreciated. I'll run that for another couple of seconds while people are joining the session. So I'll end that now. We've had a minute to fill it out, so thank you very much to everyone who filled it out. And I'll share the results on screen, and hopefully you can see there the composition of our audience. So about 13% of those who responded are OMC directors, nearly a quarter property management agents, 20% from the AHB sector. We have lots of people from the construction, professional, technical, and legal sector as well. So thank you very much for filling that up. That's very helpful to us in running our sessions. So our timetable, we've dealt with the survey. I'm going to do a quick update on MUD's news, what's going on in the sector. And then we'll move on to our main event at about 20 to the hour, presentation from Maeve Hogan, the Chief Executive of the PSRA. At about 1:15, we'll have a question session. So we've received a lot of questions in by email, as we asked in advance. So questions were gratefully received, and we'll go through those with Maeve and some of our colleagues, and we will finish on time at 1:30. So with that, I will move on to our MUD's news sector. We've dealt with the survey, thank you. Some housekeeping before I get into the news section is we have a chat function, so I'm joined by my colleague Graham Fryer in the background. So if you have any problems with the audio or the visual, please pop those queries into the chat and let Graham know, and we'll try and resolve those. We have, as I said, received lots of questions ahead by email, and we'll deal with those in the questions session. If you have questions today, we will take them by email later on. We have time only for those questions we've received in advance. We'll send out the slides to you after the session. Don't worry about that. The session is being recorded for future use. It will appear on our YouTube channel, and we will send you a link to the recording so you can watch it back as well in your own time. For those of you who are new to these webinars, we're the Housing Agency. We're at 53 Upper Mount Street. We work with the department, local authorities, approved housing bodies, and stakeholders in the sector to promote the building of sustainable communities. A quick update on MUD's news in the sector. As we mentioned at our last webinar, which was on the 30th of January, about launching our insurance guide. Company law provides for virtual AGMs until the end of 2024 for those who for those who need it, and there is a review of the Companies Act legislation going on, so that may be a permanent measure in due course. A reminder of the underpinning legislation for that measure, the statutory instrument, and indeed the COVID Companies Act 2020, and you can refresh yourself on the fine detail of how to run a virtual AGM and the provisions you must comply with in that context under the legislation, perhaps in your own time. A link to the legislation is there. What we ask you to do as part of our reach out into the sector is to help us understand the number of, help the system understand the number of OMCs in the country. So if you're a management agent, a solicitor, or indeed a new director, you're incorporating an owner's management company on the CRO core system, please tick the box to identify the company as an OMC. We've highlighted it there for you on the bottom of the page. And equally, when you're filing for existing owner's management companies, when you're filing your B1, your annual return to the CRO, please make sure to tick the box as well, and we'll get a much better sense and indeed census almost of OMCs in the country. Quick reminder, as part of all the filings, that directors must provide their PPS numbers to the CRO, and there's guidance available from the CRO on their website, and indeed from colleagues in the Corporate Enforcement Authority. Some background reading on those particular topics is available in a piece of writing I did for the Surveyor's Journal back in October 2023, and it's there on screen for you, and we've pulled out the main details on the A1 and the B1, so hopefully that's helpful. Some other bits and pieces, some nuggets of information. Our colleagues in our sister organisation, the Office of the Planning Regulator, have published some good guides and leaflets, one of which is the Guide to the Taking in Charge process with commentary on MUDs and OMCs. They have launched guidance on the large-scale residential development process, their planning leaflets. One of the more recent documents is their practice note on planning enforcement, worth a look as well. And very recently, they issue a series of legal digests on case law in the planning system. So links there for you. A reminder that details of the remediation scheme for fire safety defects, the interim scheme, that's available on our website, and I've included the link there. With regard to Housing for All reforms, some updates on parliamentary questions. Again, this is available to you when you get the slides, and you can perhaps read it in your own time there. A reminder of the resources available on the Housing Agency YouTube channel. Our 6 designated subject matter expert training sessions on the MUD sector, and we now have 18 videos on our YouTube channel dealing with a myriad of issues for MUDs. Our most recent webinar on the launch of our insurance guide is available. A recording is available on our YouTube channel, and there's a link to where you can get that guide as well on our website. Interesting to see an article in the Sunday Independent just gone on a lot of the issues in buying an apartment and multi-unit developments, reflecting and mirroring some of the guidance on our own website on buying a home in a MUD, available again on our website there. The link is there. A lot of these topics are covered by our recent, last year, our compilation of writing on the MUDs and OMC sector, a link available to you, and a reminder of our guides on company law, covering a lot of the frequently arising matters for OMCs in the company law space. In the context of today's presentation, a reminder that we have published a guide to engaging a property management agent. So some useful hints and tips there for OMC directors, and you can see all the content there. That's available on our website, covering a myriad of issues there. A reminder that our next webinar is on the Wednesday, the 13th of March at the later time of 1 p.m. That's why I've highlighted it in yellow on the top of the screen. And that will deal with waste management and recycling in MUDs, a very significant issue for a lot of you. We have expert speakers from local authority sector and from the Irish Waste Management Association. So we're very much looking forward to that. 13th of March. Details are now on our website, available to register on Zoom. In terms of setting the scene for Maeve's session this afternoon, I'm very grateful and delighted to have Maeve with us. It's always useful to maybe put on screen a depiction of all the actors in the muds sector. At the centre, we have the owners management company in the salmon pink box, I guess. That is made up of the owners and members who elect the directors. They hire the property management agent, and that property management agent is, as you can see in the bottom right, regulated by the Property Services Regulatory Authority. And of course, we're delighted to have with us today and very grateful to Maeve Hogan, the Chief Executive Officer of the PSRA. Maeve was appointed CEO in August 2015. She's a career civil servant and has served in roles in the Department of Justice and the Garda Inspectorate. And before her appointment as CEO of the PSRA, Maeve served as Chief Inspector with the Private Security Authority. So very grateful to Maeve for her time and availability today, and indeed her colleagues. I will hand over to Maeve at this stage, and I think Maeve can share her screen, and I think Graham will spotlight. So delighted to have you, Maeve, and over to you. Thank you very much.
Good afternoon, everybody. Delighted to be with you, and thanks to David for inviting the PSRA to address you today. A raft of information there from David. I'm sure there's interesting articles there for ourselves in the PSRA as well as the participants here today. Glad to note that there are, a significant number of directors and management agents on this attending the presentation here today, and others around housing bodies and professional, technical, legal. So you're all welcome to the presentation. The presentation really today is, from our perspective, the PSRA's perspective. We hope to give you kind of an overview of where we're at, our role and our statutory role. And I suppose some of the questions submitted really are not relevant to the PSRA, and we'll address those along with my colleagues towards the end of the presentation. Just to note that the PSRA will not be providing any legal advice here today. We are not in a position to provide legal advice to anybody. Legal advice should be sought from your own appointed independent legal advisor, and I'm addressing that to either management agents or the directors in an OMC. We will try as best help you with your queries, but we certainly will not be providing legal advice. And again, as I said, questions from the audience, we'll address the relevant and related to the remit of the PSRA only. Some of the questions relate to company law and outside our remit. So just kind of to state that from the get-go. So just a bit about the PSRA. We're established in 2012. We're established to establish a licensing system, so we'll license management agents. So any of the OMCs on the call will have a management agent licensed by the PSRA, and we grant them a license based on their education, qualifications, or past experience in providing property services. We set out to maintain standards and a code of practice. Again, all these documents are available on our website. A key provision of our legislation is consumer protection legislation, and that's protect the consumers in relation to the provision of property services. We establish and administer a complaints process, so we will discuss that later in the presentation about the complaints process and who we accept complaints from. We manage and maintain a sector compensation fund. So the sector contributes to a compensation fund on an annual basis. And so when they're renewing their license, they are required to contribute to the compensation fund that's in place. And we'll discuss that later. Compensation fund, just for information, is in relation to the proven dishonesty by a management agent. And above all, as we are doing here today, to increase public awareness and confidence in the sector. So we'll march on. So in relation to just an overview of ourselves, as I said earlier, established in 2012. Head office for us is in Navan. We've also a secondary office in Bishop Square in Dublin, where our investigations unit is held. As David outlined, we are under the remit of the Department of Justice. I report into a board of the authority of 11 members. And just for a point of interest, number of licensees that we have totals almost 6,000, of which just over 4,000 are employees and 1,700 employers. So that's reversed there. I spoke about a code of practice, and like with any sector, there's a code of practice in place for management agents, where we expect licensed property agents to act professionally in their engagement with their clients and customers. Honesty, again, a lot of these principles don't need to be explained. Act with integrity, confidentially. A lot of agents will come into receipt of a lot of confidential information, and there is an expectation there that you treat that information with confidence with confidence, and that it's not used for any other purpose. Again, open, effective communication, and I can't speak highly enough about this principle of open and effective communication, and that's for everybody on the call. We all know how effective communication can be in resolving issues and resolving disputes or concerns, or informing people in relation to a particular process or procedure or reason for undertaking a particular action. If there's open, effective communication, we find that a lot of those complaints that we receive could easily be dealt with more locally between an OMC and their management agent, or between the management agent and the OMC. So communication, as we all know, is a two-way street. And professional development, we have in place a statutory professional development CPD programme for all our licensees, including management agents. And they're required to do 5 hours CPD annually for the sector. Just very quickly around licensing. So there's 4 license types that the PSRA license: auction of property other than land, so your typical auction of cars, auctions at a mart, auctions of goods and chattels, that's the A license. B license addresses the purchase or sale of property, the likes of houses, lands, apartments. So license B allows you to do that, and it also includes the auction of a house or the auction of an apartment. License type C is the letting of land, so the letting of a property, the letting of an apartment, the letting of a house. But key today is property management services. License type D is the property management services. So when you're engaging, as an OMC would engage a management agent, they must have the license type D. And that can be checked very quickly and easily on our register, and I'll discuss that later. So who needs to be licensed? Businesses and companies. So the business management agent's business and their employees who are providing a property service are required to be licensed. That includes, partnerships, companies, partnerships, sole traders. It also includes the licensees, as I said, principal officers, employees of that company or of that partnership. And any management agents manage the public areas on behalf of an OMC. So when you engage a management agent, it's very clear to the management agent what the role and functions is in relation to the public areas of that apartment complex, or whatever the area the OMC has responsibility for. I spoke to you about property management services is a license D category. So each agent each employee is provided with a kind of a credit card sized license card. And this is what it looks like. So you'll see the expiry date, which is critical that they are licensed, to ensure that how do you know if they're licensed? You can ask for the for their license card, under which you'll find their expiry date of their license. Their license number, the service they provided, and I've highlighted in red here, it's D for management agents, a D license, and their name and their employee of whoever their employer is, and a picture. There is a picture on their license card. So you can ask to see the employee's license card at any time. They should carry it with them at all times. Issuing of licenses. So license duration is for 1 year. So they are required to renew their license annually. You as a as an owner management company can check if your management agent is licensed and continues to be licensed. You shouldn't assume that they continue to be licensed. There may be for some reason they haven't renewed their license. Check the register. So you check the register on PSRA and look for the property licensed property agents, and you can search for your agent on that register. as I just outlined, a credit card size identification license card issues to every employee. So you can ask to see that, ask that licensed employee to produce that card if required. Again, a card must be produced on request. Principal officer and employee can be licensed for services for which their employer is licensed. So you may have an employee who has an A, B, C, and D license, but their employer doesn't have the D. So it's where the employee can only be licensed for services for which their employer is licensed. So the licensed employer must have a D license, and the employees can operate as an employee of the D license in providing management services to OMCs. And again, how do you know if your management agent is licensed and continues to be licensed? And this is critical for OMCs, that we advise them to check our register. It's easily accessible, easy to search on it, and it only takes moments really to search if your agent is licensed and continues to be licensed. So we have our PSRA. Please go on to the Licensed Property Service Providers section of it. The register contains the names of the licensees, their business address, and their trading names if applicable. And the expiry date, critically the expiry date of their license. Again, worthwhile, just go on to our website and have a look at the register. Familiarise yourself with the contents of the register. Just for note, the register will also contain those who are not currently permitted to provide property services where a license has been suspended. Thankfully, we have very few of those. Thankfully, the sector is well regulated as regards licensed operators. However, don't always assume your agent continues to be licensed. There may be reasons that they're not. And if there's a reason, we have highlighted on that register. One of the critical pieces of documentation in relation to the relationship between an OMC and their management agent is the letter of engagement or a contract for service. This is a critical document, and I can't speak highly enough about this document in protecting both OMCs, directors in an OMC, and the management agent. It's a contract for service, it's a letter of engagement. What are the services that we in the OMC expect the management agent to provide? It's a detailed document. It's a document you should take your time considering. It's available on our website. It's a critical document in ensuring that the management agent provides the services that you require, and also that the management agent has certain terms and conditions also that will be contained in that contract for service or letter of engagement. More critically is that the document, a contract, which is legally binding, is signed by both the directors in the OMC and the management agent. Not forgotten about, not put to one side, not bothered to be signed. It's a critical document that protects both the OMC and the management agent. What we find is that management agents send them to the OMC and the OMC don't sign them. Under legislation, you are required to desist or step down from providing property services where there is no signed letter of engagement in place. It's something that I can't highlight highly enough. When complaints come in, the first thing we will look for is this signed document, the contract that's between both the management agent and the OMC. And where it's not signed, our hands are weakened as a regulator. Our hand is somewhat weakened. It is improper conduct for an agent to provide property services where there is no letter of engagement, signed letter of engagement in place. So this is one of the highlights of our presentation here today to OMCs and management agents to ensure without fail that there is a properly signed contract in place between the OMC and the management agent. And it makes life an awful lot easier if there's an issue of complaints submitted to resolving it very quickly. What was in place, what was signed between both parties as regards level of service, types of service, and that will be delivered by the management agent on behalf of the OMC. And it's one of, if there's any one single takeaway from today's presentation, is that OMCs ensure at all times there is a live, effective contract in place between the management agent and the OMC. In the event that matters change, circumstances change, as they do from time to time. The PSRA strong recommendation is that a new letter of engagement is signed between the management agent and the OMC. Again, it's critical that you have in place a relevant and signed letter of engagement that's valid and is signed by both parties, and that in the event that there is no signed letter of engagement in place, again, as a regulator, it makes our lives a little more trickier and more difficult. I think the text here just reflects everything I've just said. The LOE is a contract for service, and it's a legally binding contract. So you know, it has standing in the court. We have seen cases where you know, a client has used the contract, the signed letter of engagement, as a critical document in a legal dispute. Any dispute about its terms would become a legal matter. You should seek legal advice prior to signing the LOE. So just a word of advice there to LOEs, sorry, to the OMCs. You know, when you are signing that letter of engagement, it is a contract. It is a legally binding contract between both parties. So you should seek legal advice if there's any issues of concern that you have and you want to highlight or change within that LOE. Again, critically, must be signed and dated by the property management agent and the OMC. And OMCs should ensure that there is a valid LOE in place between yourself and your agent. Property management agent will only take instructions from persons who are identified in the letter of engagement to engage with them. I just might flick to the next slide just to show what we expect there. If you see in this second highlighted area there, persons authorised to instruct the agent. OMCs, as we know, have many directors. You know, they can have multiple directors, but who is the agent taking instruction from? And this provides clarity to the agent. The names of the director, or the names, whoever the OMC decides, are the authorised persons to instruct the management agent. Again, that's critical from the management agent's perspective. Who are they to take instruction? Very clear who he can take instructions from and who he can't take instructions from, the opposite. And the OMCs, again, we understand that, you know, the directors can change from time to time. If the named authorised persons to instruct an agent changes, you should update your letter of engagement and advise the management agent. You know, one or two of our directors have left, or one or two of our authorised persons have left and are no longer willing to act as authorised to take instructions from the agent. We've changed them, and the new details should be included on the LOE. Again, you should be proactive about that the management agent knows exactly who they take instructions from. Just go back up to our previous slide. So the property manager will only take instructions from the persons who are identified in the LOE, and that's only fair to the management agent. He needs to be very clear who he can take instructions from. He can't be taking instructions from all 10 directors on an OMC. That's not operationally, that's not going to work. And OMCs need to just consider who can give authorization to an agent to do X, Y, or Z, or whatever is required on behalf of the OMC. The PSRA will only liaise with the identified persons by the OMC in relation to a complaint received from an OMC, or in cases where such persons have resigned, the PSRA will accept a complaint from a newly identified persons. Again, we need to understand who we can engage with in relation to issues of complaint. So it's critically that that piece of your LOE is kept up to date. Again, if there's any changes at all to your circumstances in relation to the provision of management services by your management agent, update the letter of engagement. You know, it should be a document that's a kind of a live document for all OMCs, that any changes must and should be reflected in the LOE. I would suggest a new LOE. You can issue a side letter possibly to amend one particular element of your LOE, but I would strongly be recommending a new LOE. Again, engaging with your management agent and the OMC, engaging together, communicating together, and agreeing what is the best way to proceed with any changes to the contract for service, the legally binding document that both parties have signed up to. Again, just more about the letter of engagement. Strongly recommend that, again, as I said, a new LOE is issued when there's a new directors appointed or, minimally amended. I would recommend a new LOE. Again, that's a communication between yourself and the management agent and the OMC in relation to how to proceed. An OMC can request that a non-mandatory clause of an LOE be changed or amended where they are dissatisfied with them or wish to enhance it. So the LOE has asterisks at certain elements. The content of the asterisks can be amended, but the heading must be included. So where there's an asterisk, the heading must be included, and text contained is sample text, so it can be amended with agreement by both by either or one or both parties. By both parties, there must be agreement to the amendment, because both parties have to sign off on the agreement. Where both parties fail to come to an agreement or where there's disputes, either party should not sign that LOE. It is a binding contract. Once you sign it, it's a legally binding document. Suggest, if you can't come to agreement, that you contact a legal advisor or mediate out the issue. If you can't come to an agreement, I would suggest to either party, you can't sign the LOE, and maybe one or either party just walk away from the situation, or for an OMC maybe to find another management agent. But if you sign an LOE or as a contract for service, it's a legally binding document, and that's the conditions under which the service is to be provided. In such circumstances, management services are provided by a licensed agent with whom there is a valid LOE. Again, licensed agents, look up our website. Is your agent licensed, and is there an LOE, a valid LOE in place? If it's, keep an eye out the duration of your LOE. If it's due to expire, engage with your management agent if you wish to continue and extend, enter into a new contract with them, that you make sure that you do it in good time, and that there's a valid LOE in place then for the new term with the management agent. I know David spoke about, they have housing agent has its own document there, engaging a management agent. Just pointers that we would point out from complaints we've had to deal with in relation to management agents, and complaints from management agents and complaints from OMCs themselves. One critical issue that I have concern around, and just want to raise it here today, is, as you know, in the OMCs have a relevant bank account. Who has access to your bank account as an OMC? Who has access to your bank account? Does the bank account require more than one signature? So if what I'm asking there is, I understand, OMCs and directors are under fierce pressure. You have the day job and you have this additional work as a director. But the key issue is, who has access to your bank account? Has your management agent access to your bank account? Has the management agent full access, in the sense does not require the signature of anybody else from an OMC? If that is the case, that's your decision as an OMC, that you've given full access to a third party, your management agent, who I'm assuming you do trust and you have a good relationship with. But what I'm asking is, are you satisfied that your management agent has full access to it? Or is it a situation where you have in place that the OMC is required to sign off? Again, one appointed person of director and OMC must authorize every payment from the relevant account. These are questions I'm posing to you because we will go on to discuss practical concerns that have arisen around that. A key question again: have former directors or property management agents, employees, been removed from your bank mandate? Who can access your relevant account? We, as I said earlier, directors come and go. As an OMC, are you assured that nobody else has access to your relevant account other than those persons mandated? Previous, directors who have left your OMC, are no longer director in the OMC. They should be removed from the bank mandate. And maybe that's something you would instruct your management agent to do on your behalf, or you can do, obviously you can do you can do that yourself. And keep asking, I suppose the question we would ask, how is this confirmed, that there's no former directors or former employees of a property management agent listed as mandated on your relevant account? Again, it's the OMC's money. It's money's collected from the owners in the OMC, and we don't want anything to happen to that money. What, if any, decisions or payments can be made by a property management agent without prior consultation with the OMC? Again, this should be agreed with your management agent, that in certain situations the management agent can process particular payments and make payments on behalf of the OMC without prior consultation. Or is it the case that the OMC wants to be consulted on every payment? Again, you have to meet a medium there, where the management agent does have a job to do to ensure that payments are made. And if the management agent requires one signature or two signatures from a director in an OMC, to be fair to the management agent, the directors should be coming back promptly to the management agent, that the agent shouldn't have to be following up with directors in an OMC to please authorize this payment, it's outstanding, and please authorize this payment. There again, good communication between the two parties will certainly ensure that there is a smooth operation between the agreed method of how a management agent can ensure that payments are made for different services. And again, another key and critical area that I want to address is, has the property management agent taken out and paid for appropriate insurance cover for the OMC? Insurance cover for an OMC, like any property, our own properties, to ensure that the public areas are covered and properly insured, is that a property manager takes out insurance. I'm asking really OMCs to ensure that your OMC has the appropriate insurance in place and that it's valid. And again, I'll speak to why I particularly want to raise that with you. Property management agents, as part of their instructions in the letter of engagement, the service that they will deliver is to ensure that there is proper insurance and cover. He can only do that, or she can only do that, the property manager can only do that if there's money in the OMC's service charges, if there's a budget there for the to pay for the insurance. If there's no monies there, or lack of monies there in the relevant account to pay for insurance, that is something that the management agent should be advising the OMC well in advance, to say that there's limited funds there, or insufficient funds, or no funds there for insurance cover. Again, good communication between the agent and the OMC will ensure that issues like this are discussed well in advance and not left to the last minute, where insurance cover is about to be cancelled. The policy is about to be cancelled because there's insufficient funds, or the management agent hasn't done what they're contracted to do to ensure that there is insurance in place. Again, I'm asking the OMC, how do you know if you have insurance in place? Again, I would suggest that communication between yourself and management agent, and maybe having sight of that insurance policy. Again, this is for the OMC to decide how they want to address that issue. Just moving on, I know time is marching on us, in relation to types of complaints that we receive in relation to OMC's poor service provision, in matters relating to, has the OMC engaged with the property management agent regarding poor service provision in the first instance and prior to making complaints. So often we get complaints about poor service provision and that the OMC haven't engaged directly with the management agent. Again, a communication process in place there. You, the OMC, have engaged and employed a management agent. You should have a relationship with that management agent. If they're not forming, or if they're not addressing issues that the OMC has directed, that's in the first instance should be undertaken and addressed by the OMC directly with the management agent. Like, the PSRA shouldn't have to be dealing with poor communication, which maybe the management agent doesn't understand, or there was a miscommunication from the OMC around a particular aspect. So a lot of those issues could be directly resolved locally before we have to get involved. We get complaints around no letter of engagement. I've spoken extensively here today about, and I hope the message has gone out clearly, that OMCs and management must have a valid LOE in place. You're required to have a new LOE every 3 years, and that's a MUD Act requirement. Must nominate directors to engage with the property management agent, and again, if those directors change, you should update your LOE. Any amendments to the LOE, we would recommend that you draft a new LOE and put that in place. Document all services required of property management agent. Again, that LOE has a section in it of the services that you require as an OMC of your management agent. And again, both parties are signing off on those agreed services. Just a note about unlicensed operators. You should report unlicensed operators to ourselves. Again, how do you know your management agent is licensed? There is a register. Go onto our website, psr.ie, check your management agent is licensed. We get a lot of queries around fees and outlays. Critical is signed contract, that the management agent knows exactly what fees are agreed. The OMC knows what fees are agreed and what outlays are provided for. We really find it challenging to deal with complaints where there's no signed LOE in place. What was ever agreed? What was the intention at the beginning of the contract? And if a contract runs out, both parties should be aware of the date of the expiry of the LOE and put in place in good time a new contract for service, a new LOE, or if you don't want to renew that contract, that you go and find a new management agent for the OMC. Client account breaches, again, we get allegations that the management agent has paid for matters that the OMC hasn't agreed. And what we often find is one director isn't in agreement and another director is in agreement. So again, that piece in the LOE where the agent, who the agent can agree with and engage with as part of providing the services, is critical here. Who does the management agent take instructions from? Is it all 11 directors in an OMC? That's not workable. Who are the two people? We suggest two people. It might be two, might be one, might be three persons that the management agent can engage with and take instructions from. Again, conflict of interest in relation to management agents providing property services in an OMC, and we've dealt with that in the minimum standards. Again, if there is a conflict, make your employer, the OMC, aware of any conflict of interest that exists. Matters which we don't investigate, complaints by members of the OMC, tenants and landlords against an OMC or the property service provider. The employer of the property service provider is the directors in the OMC, and that's who we will take complaints from. If there's owners or tenants in an OMC and want to make a complaint about a management agent or the service provided, they should go directly to the OMC, and in turn, if the OMC isn't aware of it or wants to make a complaint, then they can contact us in relation to that particular complaint. But critically here for OMCs, the management agent can only act on the instructions of the OMC, and critically, who does he take instructions from? And that's what we were looking for. Who can the management agent take instructions from? And did they instruct the OMC the management agent to undertake service X or Y? And that's where we start with our investigation. Such matters should be the first instance be referred to, as I outlined, to the directors in OMC. How accessible are contact details for directors in OMC? These are critical that the directors in OMC are made known to the owners in an OMC. Matters for complaint from tenants and landlords are more matters for the OMC, or if there's issues with tenants and landlords, they're matters for the RTB, not the PSRA. Again, OMCs are covered, as you know, by the MUD Act, Multi-Union Development Act, and are subject to company law. Complaints against OMC, allegedly they are carrying out property service in their own multi-unit without a license. So if there's a management agent undertaking property services without a license, we definitely want to know about it. But however, OMCs are entitled to self-manage and not obliged to appoint a property management agent. Now, that said, the level and size of apartment complexes that are going up all around, cities and towns, it is strongly advisable that, self-management is an awful lot of work, and management agents are the experts in providing property services to OMCs. And we would advise that you do appoint a management agent who has experience in managing public areas and procuring services and a track history. And, OMC should, make sure that their management agents can deliver everything that's in that contract for service, that they're capable of delivering it. Just very briefly, based on complaints that we got and that we couldn't investigate, we extended the remit of the PSRA that we can investigate matters relating to additional matters, and we've just outlined them here. This SI minimum standards came in on the 30th of November, extending the remit of the authority on matters that we can investigate and address service delivery around timeframes and transfers of monies. Again, all itemised in your letter of engagement, what you as an OMC wants from service, the level of services and timeframes around services by a management agent working on your behalf. Again, contact and behaviour. Conflict of interest, we spoke about. Licensee shall not be a director in a management body. That definitely is a conflict of interest of a multi-unit development where the property managers are provided by the management body, by the licensee, the employee of the licensee. So a licensee should not be a director in a management body in an OMC. They are providing a service. The OMC should hold the licensee accountable for the service that they provide. However, a licensee who is a unit owner, where the licensee is a unit owner, multi-unit development, may become a director in the OMC who is responsible for that development. And where a licensee is a unit owner in development and intends to provide a property services to that development, the licensee should notify in writing to the secretary and all directors of the owner management company of that effect. So there should be no surprises that the licensee as a management agent providing service to a particular OMC is a unit owner in that OMC. Just very quickly, we do have powers of prosecution for offences relating to unlicensed trading, matters relating to client accounts, and then more generally, general offences. We have powers of prosecution. But again, we need to investigate, we need evidence, and the recommendation to prosecute then taken by the authority. Just to demonstrate in relation to an OMC, and lots of you probably read this in newspapers more recently. The PSRA received a complaint from an OMC concerning their former property management agent who was alleged to have misappropriated funds from the OMC's relevant account. I spoke to you earlier about who has access to your relevant account, who can sign off on that account, who's monitoring your relevant account, who's looking after the monies of the OMC. The property management agent, in this particular case, the complaint we received, was also alleged to have failed to put insurance cover in place. Again, I spoke the importance of insurance cover for an OMC and OMCs to ensure that they have insurance and adequate insurance in place for their OMC. This particular management agent, following investigation by the PSRA, was found that this particular agent had misappropriated from two OMCs a total of 116,500 and failed to put insurance in place on behalf of one of the OMCs. The PSRA sanctioned the agent by revoking their licence and was permanently prohibited from applying for the PSRA for a licence again, so not allowed to ever work as a property management agent in the sector again, and imposed a financial penalty on the agent of 145,000. Again, we're required, following our own investigation, we must go to the High Court to confirm our sanction of revoking that management agent's licence and imposing a financial penalty of 145,000, and that sanction was confirmed in the High Court. Separately, we are required to report that fraud to the guards, which we did. So a criminal investigation then commenced, and the agent was arrested by the guards and recently appeared before the Circuit Court, pleaded guilty to 52 counts of theft and was jailed for 3.5 years. So really what I want to demonstrate there today, the importance of the relevant account and the importance of ensuring that it is managed correctly, that we do have the powers to investigate theft, as we did in this particular case, and brought it to the attention of the guards, and you can see yourself the results of that criminal investigation. We do have a compensation fund. It's a sector funded fund where there's dishonesty proven by the property service provider, by your management agent. Again, there must be dishonesty by the agent, and we must of course investigate and find proof of same. And again, it's a sector funded fund. There's information on that, our own contact details and information in relation to ourselves. Again, all available on our website, psr.ie. And that's it from me, David.
Thank you very much indeed, Maeve. A fantastic presentation, and lots of detail and information and guidance for everyone in the sector, be they OMC directors, property management agents, or anyone else involved. What we're going to do is run a very quick poll, or indeed a question, based on, I suppose, the information that Maeve has gone through there. It's a multiple choice question, so if you could kindly maybe give your answer there in relation to the remit of the PSRA. So which of the following matters is within the remit of the PSRA? Is it A, transfer of common areas from the OMC, from the developer to the OMC, amount of annual management charges set by the OMC? Is it C, the contract between the agent and the OMC, or is it D, the holding of annual general meetings by the OMC, or is it E, all of the above? And gratifying to see that the predominance of the answer is going towards one particular answer, and that is, I suppose, testament to the message that's going across. For those who are answering other than item C, perhaps you would revisit the presentation and go onto YouTube and check the guidance otherwise. So I'll end that poll now. Plus, just a little bit of a tester there for people. So thank you very much for that. And I'm going to quickly share the results there. So 81% of you got it right. As I say, for those who had an alternative answer, perhaps you would revisit the presentation and the guidance available. We have 10 minutes or less indeed for questions, and we did facilitate the opportunity to people to send questions in advance. We are joined by Maeve's colleagues, Antoinette Gavin, who is the head of investigations, and Roisin McGill, who is the head of licensing with the PSRA. And we will jump quickly to the questions. We have received them in advance. I suspect that a lot of them have now been answered by the information that Maeve has kindly given across. But some of them are relevant to the remit of the authority, and some of them are not. The first question that came in was a multi-part one in relation to, I suppose, the letter of engagement and the timelines around which the agent has to get the letter of engagement signed in the context of the AGM that the OMC holds. The next part of the question was around, I suppose, obtaining a license and the skills shortages in the sector. So Maeve, I might throw those over to you to just comment briefly.
Yeah, we've discussed those questions in advance, we had to look at them. I think in relation to, if I understand the first part there, in relation to a budget and agreeing a budget for an OMC and the management fees of an OMC, like, it is open. If it's it's the signing of an LOE, the appointment of a management agent, they can happen generally will happen at different times, but not necessarily at the one time. But anyway, that said, like, if it's a case that there's concern around the budget for the management agent and having enough fees and collection of fees, it is open to an OMC to hold an EGM. They don't have to wait for their AGM. If they need to discuss something or change on something, it is open to them to call an EGM. And that's really how I'd address that. It's it's something, again, communication between the OMC and their new management agent, and agreeing fees between them. Is there enough fees? And if there isn't enough fees to meet the, we'll say the fees of the new fees of a management agent, I think the practical thing around that is, you call an EGM, need more money. How do we offset against their fees against something else? Again, something for the OMC to meet and discuss themselves and agree how they will meet the fees of their new management agent.
Very good. And I suppose the other parts of the question were around the licensing process. Maybe you might like to comment
just
on that.
There's a few questions around that, and Roisin McGill is head of licensing. I think there's a few questions there around ability to acquire management agents and employ management agents and qualify management agents. I think there was one particular question there that they've 2 staff members and they're trying to get them licensed. Our licensing requirements haven't changed. We are looking at them and we are looking to make changes to them, but they have not changed in the last number of years. So there hasn't been any change in our from our end. I mean, what is available, and I'm hoping management agents do understand, there is an apprenticeship program, a very effective apprenticeship program in place, a 2-year program where employers employ an apprentice on a 2-year program. And on I presume 5-day a week situation where up 1 day a week they attend an apprenticeship program, be it through Dublin, Cork, or Galway, where the location of 3 programs, and they have been producing, apprenticeships with A, B, C, and D, all 4 license types. The apprenticeship program qualifies them for all 4 license types. Like there are students coming out of those colleges, once they've finished their apprenticeship program, generally they do stay with their employer, but not always. I mean, they are available. But I mean, if employers are listening here today, they should consider, and they have staff members, and they want to qualify them for a license. A very effective way is to sign them up for the apprenticeship program. Now, there is requirements there on the employer through a monitoring and a mentoring part as well. But it's a very effective way of qualifying staff you're already employing and giving them that qualification of becoming a licensee or a management agent themselves.
Excellent.
I don't know, Roisin, do you want to add anything else to that?
Yeah, no, I agree with you there. That it's a good route for anybody that you have. Like the question was in relation to kind of they're working under somebody, but that's not lawful experience. That's in a support role, and it's only lawful experience and a qualification or combination of the two that is a route to getting a license.
I'll just add there, Roisin, just to end on management agents is a very responsible role. The level of responsibility that a management agent has is significant. Again, around insurance for the property, making sure fire safety issues, appliances and everything are in place. So it's a very onerous and responsible role. And, we want qualified people being licensed in relation to the role.
Very good. I suppose the next question that came in was around the involvement of the PSRA in life safety systems, in monitoring those in apartment developments, which I think is fair to say is well outside the remit of the authority.
Outside our remit.
So we might jump on. And the next question was about building investment fund provision, and again, I think a matter for OMCs and agents themselves.
Yeah, I mean, all I'd say on that is our understanding is quite possible there's only one owner. I mean, if one owner wants to build apartments, and there is one owner, there is no requirement for an OMC in that particular situation where there is one owner.
We had a question about legal representation for owners management companies. So an agent who has lots of OMCs that don't have legal advisors, and I suppose I'd open that question up to you briefly.
Yeah, well, I wasn't clear on that question. Yeah, so it's OMCs that don't have legal advisors, but they should have legal advisors, and they should have that in place. That a budget for legal advice and a solicitor. In the event that they need it. And that's all I really want to say. And that's a matter for the OMC and how they wish to operate. But they should have legal representation.
I think that's
when they require it.
I think that's a central message coming from today, is that what we're delivering here is guidance, signposts, information to which to refer, and the legislation, and that agents and OMCs do need to take the time to get legal advice specific to their own circumstances, be it the property, the legal documentation, the circumstances, the history, the parties involved, all need to be contemplated by someone who is independent in that legal advisor space. There was a question in relation to agents and providing responses to requisitions under the MUD Act. That was another question that came in.
Saw that one there, yeah. I think what we'd say around that is where a vendor, somebody owns the apartment in an OMC, wants to sell it, and that the solicitor's vendor wants particular information from an agent. I'm not clear why an agent would provide that information.
Yeah,
I think myself and Antoinette discussed this. I mean, failing that, that information, the solicitor should be writing to the to the OMC directors in the OMC as well. But then again, there's another point that should be in the letter of engagement as a service that the management agent is prepared. They may charge for it, and that's you know, that the management agent is right to do that. It's, you know, additional work. But that should be in contract for service. You know, there's ample of space there for services to be put in and included in that letter of engagement and signed off by both parties. I think it's unusual that an agent wouldn't do it, but if there was an issue or whatever, A, is it in the LOE, and B, if it's not, the solicitor, for the vendor's solicitor, will be going to the OMC looking for the information.
And the agent should inform the solicitor who the correct person is to write to, the director's details and stuff, so they can get that information.
Very good. Look, it's coming up to 1:30. Unfortunately, we have run out of time. We will commit to coming back to people by email on the questions that they have sent in. I want to express my sincere thanks to Maeve, to Roisin, to Antoinette, to Maeve's other colleagues in the PSRA who were instrumental in getting this session up and running and putting all the work into delivering a very insightful and valuable hours guidance on the regulation of management agents. Thank you very much to all indeed. Thanks indeed to my colleagues, Graham for his technical support today, and Vivian and my colleagues in policy and practice and communications for helping to deliver this session. A reminder, I will share on screen, a reminder that our next session is on Wednesday, the 13th of March at the later time of 1 p.m. You can go onto our website now and register for that session on waste management and recycling in multi-unit developments. So with that, I will conclude. I will wish you all a very happy 28th of February. Tomorrow is the 29th, so enjoy the extra day of the year, and we'll leave it at that.
Thanks to David and on all your team as well for facilitating PSRA. Like, it's a great opportunity and a platform for us to outline our role and the issues that we have to deal with. And, you know, if we can help somebody, you know, consider their own issues and, you know, make life easier for themselves, like, it's all about effective and communication. Again, key to all of this is communication between the whole parties.
Excellent. Couldn't say it better. Thank you very much indeed.
Thanks, everybody.
Slán, everybody.
Thanks.
Bye.
Bye.